We represent the plaintiff's appellant in this case, who are owners and members of the board of directors of the Homeowners Association of the City Lights condominiums, which are located at 20 Rutledge Hill and is a 7-story condominium unit. I would like to reserve, it's a bit of a challenge to figure out how much time I want to reserve, which will become apparent, but at this point I am estimating I would like to reserve 8 minutes.
Okay, 8 minutes, that's right. We have 25 minutes per side on this one, don't we?
Oh, do you?
Is that the, no, this is another one. Sorry. We've got too many sort of similar things. My apologies. So 8 minutes out of
15.
You want to reserve that much?
Well, again,
we only allow 5 minutes for
hopefully this is the most challenging aspect of my argument.
Well, that would be good, but we only allow 5 minutes.
Well, I'll take 5.
Okay.
But I think the reason for my request will be apparent. Nevertheless, 5 minutes it is. I'm not going to take 15, and I surely wouldn't have taken 25. So, in any event, we're here representing the owners of units in the City Lights condominiums. The defendants are the Metropolitan Government of Nashville-Davidson County and 2 developers who have gained approval to build despite height restrictions of 8 and 6 stories under the downtown plan, a portion of the general plan, zoning plan, applicable to downtown for the 2 applicable neighborhoods. So the general plan provides height restrictions of 8 and 6 stories. Nevertheless, the 2 developers, one of whom is the Second and Peabody Company in the Lafayette subdistrict, has gained approval for building 3 units, 3 buildings, 36, 32, and 18 stories respectively. The second defendant developer, Centrum, has gained approval in the Rutledge Hill subdivision to build 3 buildings. Those respectively are 39, 32, and 29 stories. Again, the general plan provides height restrictions of 6 and 8 stories. So the variance, the difference between the plan height restrictions and the ones achieved by the defendants are dramatic. And that's the basis for the issue here and the basis for the appeal. Although securing these height modifications previously, the defendants secured the same height modifications previously under the downtown code height rules. The plaintiffs challenged those in a petition for certiorari, lost in the Chancery Court, appealed to this court. During the pendency of that appeal, the defendant developers switched horses and filed an application for SP, special plan zoning, seeking the exact same relief, exact same restrictions. My clients, the plaintiffs in this instance, the same plaintiffs in the prior case, came to this court, argued that the case we had appealed was moot, and this court agreed, sent it back, and the defendants are now traveling on the special plan zoning. So that's the context in which we find ourselves. The plaintiffs then sued again in Chancery Court, challenging the appropriateness and validity of achieving these height restrictions pursuant to an SP zoning plan. The complaint raised 2 substantive issues. The first substantive issue was that the special plan ordinance required expressly consistency with the general plan, including those height restrictions. So, and then the second substantive claim was that the SP zoning had been superseded, that SP zoning regimen with respect to the granting of height restrictions had been superseded by passage of the downtown code height rules in 2009. So those were the two substantive claims before the Chancery Court. The defendants moved to dismiss. The Chancellor granted the motion to dismiss. In granting the motion to dismiss, however, the Chancellor did not reach the two substantive issues raised, which I have identified, and instead dismissed the case solely on the basis, without reaching the substantive issues, that the Tennessee Vested Property Rights Act was a complete defense to the defendants of the plaintiff's claims. So the court pretermitted the two substantive issues, dismissed the case based on reliance on the Tennessee Vested Rights Property Act. It is the plaintiff's position before the court today and in this appeal that that was an erroneous application of the Tennessee Vested Property Rights Act. That act is designed and was passed to prevent a legislative, a metropolitan, a state governmental body from passing an ex post facto law. The developer had gotten, in this case, zoning approval. It was not designed to prevent a claim of illegality, arbitrariness, capriciousness by those injured by passage of the zone or obtaining the zoning restriction modification. So what's happened is that the court has dismissed the complaint based on no adjudication of either of the substantive claims, but reliance upon this other statute. Just like my asking for 7 minutes or 8 minutes, it's a bit unusual perhaps for a lawyer like me to read a portion of a brief. But again, I ask the court's indulgence to read a portion of one of the briefs in this case that will pithily and succinctly but accurately express the problem and the error of the Chancellor's decision. Quote, if the ordinance was illegally adopted, as the plaintiffs allege here, the developer's rights, and thus the Tennessee Vested Property Rights Act wouldn't apply, the developer's rights would not vest because one cannot vest in an error. The issuance of a building permit results in a vested right only when the permit was legally obtained. Again, plaintiff's claim in this case under notice pleading is it was not illegally obtained. Is valid in every respect and was validly issued. The Vested Rights Act cannot immunize the government from every zoning ordinance challenge, which is precisely what the court has in front of it. The dismissal by the Chancellor should be affirmed on other grounds rather than on the vested rights analysis. And the reason I read that quotation, Your Honors, is because it comes from the brief in this court of the defendants. Both parties agree that the Chancellor erred in application and reliance on the Tennessee Vested Property Rights Act. The developers, Metro, and the plaintiffs are all in agreement. That was at pages 7 and 8 of the defendant Metro's brief in this case. I'm not going to reach the substantive issues because they're not ripe for adjudication by this court, although that's what the appellees have briefed and appear to rely upon. But unless the court has questions, the appellants suggest that the case should be reversed and remanded to the Chancellor for further proceedings. So unless the court has questions or wishes to address those substantive issues with me, that's all I have.
Okay, thank you.
Thank you.
May it please the court, I'm Laura Fox representing the Metropolitan Government. This case was correctly dismissed in terms of it doesn't state a claim at all. And the trial court's order actually contains the right information to draw that conclusion. But the trial court got a little bit carried away with the Vested Rights Act. If the court had stuck with its analysis, for example, The court correctly quotes from Family Golf that the council does not have to be consistent with the general plan. That was very clear in Family Golf, and the trial court notes that in its order at technical record 1503. But then the trial court went on to say, therefore, the Vested Rights Act applies, and we disagree with that very last conclusory part of the analysis. But the trial court also also noted in its order that any property may be rezoned to SP. So when you change your property from being part of zoned under DTC to being zoned SP, which is a specific plan, by the way, it's a very, very specific plan. When you do that, you've got a whole new rezoning. And the trial court noted that the code says any property may be rezoned to SP. So once you're done, once you rezone to SP, you're not bound by DTC anymore. What else would any property mean? They want to do some kind of implied repeal. If you want to repeal something that says anything can be changed to SP, you need to be pretty careful and make it clear, because I don't think that that's something that is impliedly overridden. And in the trial court technical record at 1504 and 1505, the trial court's order says any property means any property. That's a specific statutory interpretation based on the plain language of the Metro Code that this court can read just as easily as the trial court. So we don't think that there's a need to remand this case. All the elements are within the trial court's order, and the cases that the petitioners rely upon that say that you should remand it, those are usually cases where the trial court had some discretion and is entitled to deference. And so
let me see if I understand this.
Sure.
Now, you say there's no need to remand because any property can be zoned SP.
Yes.
Well, aren't they claiming that the SP zoning is somehow illegal? Was illegally done, or?
No, they're saying that they're not challenging the process. They're not arguing that it fails to meet a rational basis test. And they don't dispute that it was passed, the new zoning was passed by the supermajority of council. So this is a rational basis case. This is a legislative action by the council.
So they're just claiming it's irrational or arbitrary, but doesn't that need some proof, discussion?
No,
with the trial court?
It's all in the record that you have before you.
It's all tried. It was all tried.
It's all based on their own complaint and the documents that were submitted with the complaints. So we know, and the case law is very clear in Family Golf that their argument that this does not comply with the general plan, it doesn't matter. The council doesn't have to follow the general plan. That's what Family Golf says. So it's an allegation of illegality that is so easily refuted that there's no need for further analysis.
Well, let me ask you, does a trial court need to make that initial decision rather than this court making the initial decision? The trial court relied on vested rights, and I guess that all had to do with this non-conforming use that was approved, but then all that superseded by the zoning change. Doesn't the trial court first have to address that rather than us making a decision about it?
Well, it's a question of law, so it's going to be a de novo analysis. Those are the situations where the cases say, and we cited the cases, you're affirming on other grounds. When you affirm a dismissal or a ruling on other grounds, those are usually legal questions. They're not cases where there are findings that need to be made. There are no findings that need to be made in this case. It's all in the record based on the complaint and the documents that were filed in this case. So it's Metro's position that when the council is acting legislatively, they have so much discretion. They don't have to follow the general plan. They just have to not be arbitrary. And it's not arbitrary when you say that any parcel can be zoned to be a specific plan, because any means any. And there are so many benefits that make this pass the rational basis test. There's going to be a lot of green space that's associated with this project. There's going to be increased residential units, which they object to the height, but there is a need for residential units downtown in Nashville. And they're going to realign a street. They've agreed that these housing units are not going to be short-term rentals. They're going to be rented or owned. And so those are all elements that the council found were valuable parts of this rezoning. And that's the reason why the benefits are in the record at technical record 596, beginning at 596 and going on from then. So everything is in the appellate record to allow this court to make a legal ruling, and I'm going to ask that the remainder of my time be given to Mr. Drinkwater, who represents the developer, and we ask that this court affirm the motion to dismiss.
Okay.
Thank you.
Good morning, Your Honors. We're Drinkwater, the Nashville Bar, here representing the developer defendants. First, I want to address something that I heard my esteemed colleague, Mr. Bowen, mention, and that is that there are certain height restrictions that are associated with the general plan. I think he misspoke. The height restrictions to which he refers are those that are contained in the downtown code. And we would admit that the downtown code does have height restrictions associated with the Lafayette and the Rutledge Hills subdistricts where these properties are located. There's no question about that the baseline requirements and restrictions within the downtown code do have height restrictions, which is why the developers requested, applied for, and were approved for specific plan. Specific plan is a totally separate zoning. It is for varied use of any property, for any mixed use in any land use, and when it was rezoned to SP, those height restrictions no longer applied under the downtown code. You've heard from Mr. Bowen saying that he believes that the court's final order was based solely on the vested rights. You've heard from Metro, who also believes that the trial court's order was primarily decided on the vested rights. The developers read the final order a little bit differently. The way we read the final order is that it was decided on the following grounds. First, that the SP was valid as modifying the general plan. Second, that once the SP ordinances were approved, that the developers were entitled to vested rights. And third, that an SP may be applied to any property in the county. Were this court to follow the plaintiff's argument and determine that the trial court rested its decision solely on vested rights without first recognizing that the Metro Council approved both SP ordinances, then it would ignore the pages of case law cited by the trial court, and specifically Family Golf of Nashville, which stands for the proposition that first, zoning is a legislative matter through the state enabling statutes that is reserved for the chief legislative body of the municipality, in this case, the Metro Council. Second, that a planning commission's decision and a zoning ordinance, particularly one that is approved by the supermajority of the Metro Council, is valid to amend the general plan. And finally, that when Metro Council did approve these SP ordinances by the supermajority, it did amend the general plan. Now, let's consider the general plan itself. In Tennessee, a general plan must be made with the purpose of guiding and accomplishing coordinated development in accordance with existing and future needs. And it's our position that when the Planning Commission recommended these SPs and when the Metro Council approved these SPs, it did consider under the general plan the current, existing, and future needs for coordinated development. Metro Council's approval of these SPs is a legislative act, and where the validity of a zoning ordinance is fairly debatable, court cannot substitute its judgment for that of that legislative authority. You may hear from Mr. Bowen trying to steer this court away from Family Golf on rebuttal, and I believe that would be for two reasons. Family Golf, as I mentioned, stands for the proposition that when a legislative body approves by a supermajority an ordinance that is inconsistent with the general plan, that approval amends the general plan. Family Golf was remanded from the Court of Appeals for two reasons. First, to determine whether or not the legislative body approved the ordinances by supermajority. It was not in the record in Family Golf. It is in the record here, and it was by supermajority. The second and Peabody SP ordinance was approved 30 in favor and 0 against. Centrum Realty SP ordinance is approved 34 in favor and 0 against. There's a 40-member panel of Metro Council. That is a supermajority. The other reason that Family Golf was remanded was to determine whether or not it passed the rational basis test, because the plaintiffs in that case specifically raised that issue. Plaintiffs in this case have not raised that issue. So this court has before it, which is clear in the record, is two validly submitted SP approvals recommended by the Planning Commission, approved by a supermajority of Metro Council, and those ordinances are validly passed. The process and procedure has not been challenged. The trial court recognized that in citing Family Golf, and only upon the approval of these SP ordinances were the developers then entitled to vested rights. Now you may ask, would Vested Rights Act alone prevent one from challenging an ordinance? And no, likely not. But once these SP ordinances were validly approved, then the developers are entitled to the vested rights, and that's what we believe the trial court also recognized, and its dismissal of this case, which we would ask this court to affirm. Subject to any questions, I'll relinquish the rest of my time.
No
Okay.
questions.
Thank you very much, Your Honors.
Mr. Bowen, what's left to discuss in the trial court on remand?
Well, Your Honor, with respect to fact development, if there are certain...
Well, I mean, they're claiming that everything's there, everything we need to decide. So what does the trial court need to do?
I heard that.
Yeah.
So let me be sure I answered the court's question completely. First of all, what you just heard was an argument on the merits. This is an issue of notice pleading. And whether or not the complaint gave notice of two substantive claims. So first of all, the court needs to initially address that question. So that's point one about what the trial court should do. Two, yes, there are legal analyses, because the base allegation of the plaintiffs is that the resort and the reliance upon SP zoning is illegal in this case because it did not comply with the specific requirements with regard to height restrictions of the general plan. That's a fact issue and a legal issue. And those points are addressed at pages 5 and 6 of the reply brief. As far as fact development, so first, did the complaint state a claim? The answer is yes. If it stated a claim, then there is an opportunity to develop facts. What facts need to be developed? The plaintiff's allegation and assertion, the inconsistent and illegal application of SP zoning in disregard to the general plan. So,
isn't that just a legal question?
Well, one needs to have facts. It is certainly partially a legal question, but it's not, and I know the court understands this, it is our position those issues are not yet before the court because the chancellor did not rule on them. So that's
okay.
Point one. Point two is, if we do get remanded, then there is an opportunity to develop the facts as to how the SP zoning has been applied in other instances. Did it comply with the height restrictions or did it not? If it didn't, why not? Those kinds of questions. So the answer is two parts, Your Honor. First of all, there are legal issues that were not determined by the court. Secondly, upon remand, we have the opportunity to develop the facts. And certainly the illegality allegation presumes or relies upon the fact that there was no rational basis for these actions. Again, rational basis requires some fact discovery. So that's my lengthy, but hopefully direct answer to the court's question.
Thank you.
Yes, sir. Unless the court has anything else to ask, that is the argument of the appellants.
Okay. Thank you very much.
Thank you.